Friends, there is a burning issue in the newspapers about the mercy powers of the governor and the mercy powers of the president. All of us know the presidential clemency is explained, elaborated in Article 72, and we all know that these powers are exercisable exclusively on the aid and advice of the Council of Ministers headed by the Prime Minister. So, Article 72, which contains the mercy powers of the President, is subject to Article 74, wherein it is categorically stated that the President is to exercise all his powers, almost all his powers on the advice of the Council of Ministers, except that he can ask the Council of Ministers to reconsider the advice, and the reconsidered advice is binding on the President. We know this in the Article 72. And in Article 161, we got the mercy powers of the governor. They are more or less the same, except that the governor doesn't enter the picture as far as the court-martial orders are concerned, and also the governor doesn't have the power to pardon a death sentence. He can commute, remit, he can give respite, he can give reprieve and all that. But pardoning a death sentence is outside the reach of the governor's mercy powers. Now, what's the Perarivalan case? He assassinated Rajiv Gandhi, our honorable former Prime Minister, in 91. And he was in jail. He was taken up under a union law because criminal law is a part of the concurrent list. States make laws, union makes laws. And he was taken up by the central agencies under a central law, and he was given death sentence. But please recall, in 2014, there was a verdict of the Supreme Court called the Shatrughan Chauhan verdict, wherein it is stated by the Honorable Supreme Court that when the application for presidential mercy by the death row, by the death sentence convict is taking unconscionably long period of time for the presidential decision to be given. It is a torture for the convict, and therefore he has a right to have it automatically commuted to life imprisonment. But there was a question mark whether an assassin is entitled to remission after the conversion into commutation. What is remission? If somebody who is given death sentence and it is commuted to life sentence, spending a full biological life in the prison, after spending 14 years, if his conduct has been good and the authorities can vouch for that, he can appeal to the president or the governor, as the case may be, for remission. And remission means after 14 years, he can be set free. In the case of Perarivalan, his conduct must have been good. He should have applied to the President of India, and President of India, for his actions under 72 article, should have been guided by the Council of Ministers under Article 74. But what happened in this case was that after Shatrughan Chauhan verdict of the Supreme Court, he appealed to the governor, and the governor was told by the Council of Ministers act on his application for remission positively. The governor sat on it. You know, there is no hierarchy between the governor and the president. The powers of the governor are independent of the powers of the president. And the governor should have acted in normal times. But the whole issue is, should Perarivalan have applied to the governor for mercy when the law that convicted him is a central law, and therefore the jurisdiction is that of the president? So if it's the power of the governor is bound to act on the advice of the Council of Ministers headed by the Chief Minister. But the governor doesn't have power in this regard. And the reports that we hear that the governor has forwarded it to the union government, the exact constitutionality I have explained to you. In case the Supreme Court gives a verdict saying that The governor should have acted on his own, and so much of time has passed. We take it that the governor has given positive reply. Any innovative interpretation will catch up with that. I have given you the constitutional background to the para-revalence application for mercy. Wish you all the best.